Audio check.
Teams audio check.
Sorry about the couple of minutes delay. I was just being instructed on the mysteries of IT. Now, obviously, we've only got one item on the agenda today, but a couple of things before we start. First of all, for those who are involved, I said that we were going to have a look yesterday at the CPO inquiry next week and come up with some thoughts as to where we are. Well, we sort of have, but we haven't got very far. Where we are at the moment is that we've got 3 proofs of evidence, 2 from the acquiring authority, BAL, as I will try and call you next week, but I'll probably get it wrong, and 1 from the council. The programme officer, Joanna, has been in touch by email with the numerous objectors and basically asking them if they intend to appear. What she's had back so far is about a third of them have come back and said no, and obviously those objectors remain, and doubtless the acquiring authority will deal with them. 2/3 or thereabouts, Joanna, haven't come back at all, and I mean, frankly, we don't know whether they're going to want to appear or not, because obviously the CPO inquiry, they can simply come along and rely on their objection already submitted. So it seems to us that if you make the assumption that there are no objectors attending, leaving aside the council, but no other objectors attending, it seems to us, obviously there will be the introduction of evidence from BAL and the council. There will be evidence in chief. There may well be questions from us, but there may well not be questions from any objector. So in terms of timing, couple of days with closings on the next day, perhaps? I mean, I know it's very vague, but that's where we seem to be.
So I think we are hoping, but obviously I know the land agreement is being looked at, that it may be possible that we will deal with the land objection from the council. Now, that's obviously a matter for them to comment on, but I think that's the hope and expectation. As far as the other parties are concerned, we have no indication that any of them intend to turn up, with the possible, but we don't know about this, exception of the party, I think it's Mr. Lane, represented by Amanda Sutherland. Certainly when it has happened a few times to me, where I've been in that type of experience, what has typically happened is that we've very briefly opened the inquiry, sort of just explain things. Quite often the inspectors have said, look, we've read the evidence, sort of tender the evidence or take it as read and update us on what you understand to be the position in negotiation so that it's right up to date. That, you know, those witnesses simply respond to any queries that the inspectors may have, and then there's literally a sort of 5-minute closing that again doesn't say very much. So subject obviously to whether or not the council is there as a substantive objector. My expectation is we would get through it in a day. I've certainly done that before. But you know, that's just my expectation at the moment.
Yeah, a couple of things to pick up on, but Mr. Taylor, where do you think the authority is?
My understanding is that we're hoping to reach agreement, and that I won't even be present next week. So that's what we're hoping to achieve. Whether we manage that or not remains to be seen, but I understand we're quite close.
Yeah, I mean, certainly there was an additional proof from, I'm sorry, I've forgotten the witness's name, but for BAL, and the additional evidence updating as it was then a few weeks ago certainly indicated that was hoped for at the time.
Yes.
Well, if we assume for the moment that the council aren't present, then yes, it will be, with one slight proviso, it will be a matter of updating effectively where the acquiring authority is on the number of rejections. The one slight proviso, as obviously we all know, this Section 78 is a transfer decision, and the CPO at the moment remains with the Secretary of State, so we'll be writing a report, although just as an aside, I gather they're still thinking about it. But, well, there we are. Now, if you remember when we were talking about the difficulties that frankly puts us under, we suggested, and nobody frankly could think of a better way of doing it, that we would issue the Section 78 decision on planning appeal and then write a report to the Secretary of State on the CPO based on whatever the planning appeal decision was. And frankly, to do it any other way, I think would be enormously complicated. So my only slight proviso is that from the acquiring authority's point of view, we'll need to clearly understand the position of the acquiring authority if permission is or is not granted, because it'll be a sequential approach. And I don't envisage that taking any amount of time, but there it is. There is something there to consider. But otherwise, I think that's where we are. I've seen correspondence from Ms. Sutherland. Yes, I think it's a Mr. Lane, who she may be representing as an objector, but I don't think that's entirely clear at the moment.
Agreed.
I do know, however, that she is acting as the appellant's agent in a totally different appeal here in North Somerset on Tuesday and Wednesday. And she's already indicated that that could be problematic if she was instructed to appear, but I'll cross that bridge if we come to it, because obviously this CPO inquiry has been set down for a long, long time. But I think at the moment she's not actually necessarily instructed to appear, so we'll worry about that if she is.
Yes, certainly. And as far as your two, you know, the two things you'll be writing, the decision and the report, I mean, I agree with your analysis that in a sense you need to have formed your conclusion on the decision, on the planning appeal, before you make your report, although I assume, it's only my assumption, that you would in effect, because you will know where you're leading to in terms of planning, that to some extent those would be concurrent rather than consecutive activities. But I get the point that one report will come out, one decision will come out before the other report goes. So I completely endorse that. Okay, well, that's probably as far as we can take it at the moment. Obviously, the council and ourselves, and not Mr. Taylor and myself, but those, you know, those sitting in other rooms are working hard to try and resolve that. And I think we share Mr. Taylor's confidence on that. Okay, thank you, sir.
And I think I'm just double checking with Joanna. Are you writing out again to the missing people, as it were, or have you already written out again?
Yeah, I've already done that.
Okay, so I mean,
and I've said that as we've not heard from them, we assume that they're not appearing.
Yep.
And that's when Ms. Sutherland replied regarding her client.
Yeah. So I mean,
the other thing, I'm so sorry, I didn't wish to cut across the programme officer. Of course, my recollection is again on Mr. Lane that technically, of course, this is a late objection. It was not made within the period. So I think technically you need to, you know, consider whether you're accepting it. I'm not suggesting you do one way or the other, but I think it was an out-of-time objection. Yeah, but I leave that with you.
Yeah, I'm to be entirely honest with you, some time ago I was aware that it was an out-of-time objection, and there was some correspondence about whether it would be accepted or not. I think from the way I was speaking just now, the answer is yes, we're going to accept it. I mean, you're absolutely right, it is out of time.
I assume that was the case, but I was just reminding you.
I don't think we ever actually said we were going to, but we clearly are. I suppose the other point, which is unlikely now to crop up, I think, but if an objector or objectors want to appear at the CPO inquiry, but they want to rehash the merits of the planning appeal, not going there, basically. And with all due respect to those objectors who did write in on the CPO, the majority of them were in fact reopening or seeking to reopen arguments that we've just been dealing with for the last X weeks. And were that to happen at the CPO inquiry, we wouldn't be going for that because we've been there and done that. Okay, well that's I think all we can say on that. And obviously if, where are we now, Wednesday? Obviously if the programme officer gets any responses back from people, we'll keep both of the main parties posted, just in terms of the numbers and timing. But yeah, the other matter that I wanted to raise, which I know you would have raised in any event, I have seen the correspondence, and we talked about this briefly, the correspondence between the appellant and the council, was it yesterday, today, in relation to the recording of the Planning and Regulatory Committee meeting back in February. We may have misspoken, but there is a marginal correction to what's been said. It's suggested that we asked for the recording. I think what we said, and what we certainly intended to say, is that if the matter is going to be a focus, particularly on costs, then we would need to see it. It's not quite that we asked for it. But before, I've seen the very short correspondence, but my feeling on this, subject to what you both want to say, is that we are not interested in the recording of the meeting in relation to planning evidence. The planning evidence is gone and closed, and we're simply down to closing submissions. But if, and I take it that it is, but if what happened at that meeting is a matter that's going to feature significantly in a costs claim, then we need to see what happened at the meeting. And I gather that the whole meeting's about 5 hours, so we'd absolutely need to be flagged up to particular points in the meeting if that's going to be a matter of costs. Mr. Taylor, I know your side were very concerned about this.
We are concerned, and we were concerned for a number of reasons. Firstly, you hadn't asked for it to go in. That was our understanding. But secondly, well, what is happening here is an attempt to put in evidence into an inquiry after the evidence has finished. And indeed, we've actually had closing submissions from some parties already. If Bristol Airport Limited wished to rely upon something that happened at that committee meeting, either in its substantive submissions on whether planning permission should be granted, or indeed in relation to its costs application, it needed to provide that in evidence during the inquiry so that it could be probed and addressed by the witnesses. To put it in at this stage is frankly too late. It's too late because to rely upon it now without the council being able to respond and pursue various points that may or may not be made in evidence before you, for example via cross-examination, gives rise to unfairness. But more than that, it's actually not even legally relevant. And it's not legally relevant because the decision of a committee is a collective decision, as I think Mr. Henderson mentioned yesterday. Yeah. And there is case law going back more than a century. For example, the London and Provincial Electric Theatres case from 1915, which establishes that discussion at a committee by various members can't be taken to represent the collective view of the committee. The committee speaks through its resolutions. The resolution in this particular case is the reasons for refusal that you've got at CD, I think it's CD 416, isn't it? So it's just not a relevant basis either for identifying what the reasons for refusal were, or indeed relevant to anything. So there's unfairness, and it's just legally irrelevant. It's not. And if you are going to look at it, you'll have to see the whole 5 hours. I'm not going to allow you to have little bits here and there. You'll need to take the whole lot in. So you know, it would be unfair and unwise to allow this to go into evidence.
Okay. Before turning obviously back to Mr. Humphreys, I mean, I think we can kill one part of that stone dead in that although we have had a certain amount of evidence on the Section 78 on what happened at the committee and et cetera, we have heard some material on that. However, I absolutely do not want, for the reasons you've indicated, I don't want anything coming up either in this recording or in closings on the Section 78 that refer to events on this recording. I mean, I'm frankly not interested. We all know what the issues are in this appeal. We all know that officers recommended approval. We all know that members turned it down. We know why they turned it down, and there are reasons for refusal that we've discussed for X number of weeks. So in terms of planning evidence, if this document comes in, it comes in only as a costs matter, and I'll hear from Mr. Humphreys in a moment. But if it does come in, we're not going to take any account of it whatsoever in terms of planning evidence. Mr. Humphreys, so if we can focus on the document and costs.
Yes, sir. I think as the email from Elizabeth Tones makes clear, we simply thought we were responding to a request. There was a brief discussion yesterday about transcripts. I think Mr. Henderson said, look, you know, you shouldn't have a transcript, you know, and that would be inappropriate. And I thought there was then simply a request that said, oh, well, could we have a link to the to the meeting in case we need it? And Elizabeth Tones just simply supplied that. But if that's not, you know, if we've misunderstood that, and I may well have misunderstood that, then fine. It was a response to what we thought was a request from the inspectors.
Yeah, if we misspoke, it was probably me, and yeah, I apologise for any confusion. I mean, as to where we are now, put simply, in terms of the cost application that you've indicated you will be submitting, in your view, is it necessary for us, in cost terms only, to look at this recording, or are you simply going to be, not simply, are you going to be able to explain your cost application without us seeing the original recording?
I don't think you will need to see it. Obviously, Mr. Melling was there, and he made various comments about what did and did not happen, and that's sufficient for my purposes.
Okay, I think we're there, actually. And if that confusion and the concerns between the parties was something generated by me, I apologise. So that document isn't in.
Okay, thank you.
And I'll save 5 hours of my life by not having
to
look through it. Okay, so it's not in. Obviously, it's a matter that may well come up in costs, but that's a different matter. Mike?
The issue may be if Mr. Mellings has said such and such happened at the meeting, and then in the council's cost response, that's then disputed, then that leaves the panel in a bit of a situation where normally going to the minutes or going to a recording would be the obvious way to try and resolve that.
Well, so we'll cross that bridge when we come to it.
Yeah, it is a good point, though. I mean, I think what we're saying now is, no, we don't need it. But if, when we're looking at the cost claim and the cost response, it turns out, yeah, as you're saying, it turns out there's just a factual difference between the parties. It may be at that point that we just need to identify what the factual difference is. And at that point, I think we could look at that segment. If it's simply a matter of one party saying this happened, the other one saying it isn't, let's have a look at a segment where it's alleged to have happened or not. But yeah, we'll cross that. It's a good point, but we'll cross it if we need to. Okay, any other matters? No? Right, then our only business, obviously, Mr. Taylor, is down to you. I'm just thinking about timing. You were originally indicating a couple of hours?
Yes, sir. We've produced a set of closing submissions that runs to 188 pages. Obviously, I won't be reading that out. So what we've done is to produce a speaking note, which is what I'm going to be speaking to this morning.
Well, in terms of timing, just looking at your speaking note, I mean, my inclination is we just go straight through.
Yes,
without break.
That's the idea.
I have to admit that when looking over at the pile there, I didn't realise that it came in two parts, and I was getting a bit nervous.
I thought you might have been anyway. So hopefully I've allayed your worst fears there. I think it's going to take me around about an hour and a half, hour and
That's
three
fine.
quarters.
I mean, if you need a break, obviously, or anybody needs a break, just indicate. But otherwise,
I'm sure I won't. I've read out much longer speeches in the past, sadly. Just to explain, on behalf of North Somerset Council, that what I'm speaking to is a speaking note. It's been produced, given the sensible time constraint that you've imposed, for the presentation of closing submissions. And so this isn't to be taken as substituting for the full submissions that you've got, and isn't to be relied upon as such. So the document that's to be relied upon as the Council's closing is, I'm afraid to say, the 188-page, 64,000-word document that Mr Henderson and I have produced. So I shall start with the introduction. The proposed development doesn't represent sustainable development. The objective of sustainable development can be summarised as meeting the needs of the present without compromising the ability of future generations to meet their own needs, and it's to be achieved by making net gains in each of three interdependent and overarching objectives: economic, social and environmental. BAL's proposed airport extension has not been pursued with this objective in mind. Rather, BAL's pursued its own interests ahead of the achievement of the objectives of sustainable development. BAL is an airport operator so convinced of its self-importance that in its annual report it even contains a section entitled "Maintaining Our Licence to Grow," relating to its expansion proposals, as if it already possessed of a right to expand. BAL is a company so self-involved it cannot even contemplate that there might be a reasonable alternative view. Indeed, comments from its chief executive appeared in the local media on the first day of this inquiry, explaining that a cost application would be made. That said, even before he had heard the case to be presented against the scheme. That closed-mindedness, however, is symptomatic of BAL's approach to this appeal. It's a company which is so lacking in the appreciation of its impacts upon those living around the airport that it has failed to assess its noise impacts upon thousands of them. It's a company so focused on profit that it pursues growth without designing in inherent mitigation. It's a company that seeks to limit the amount it has to pay to the community by way of mitigation, and has proposed a development which includes wholly inadequate mitigation as a result. For all the warm words it puts into print, this inquiry has revealed that BAL is a company that puts the pursuit of profit before the well-being of the people its operations affect. Indeed, this is not a company which even recognises that national aviation policy requires a fair balance to be struck between its interests and those whose health and quality of life its pursuit of profit affects. This is a company that seeks expansion on a basis that is the very opposite of the approach required by government. It is a company stuck in the dark ages of aviation planning, but we are in a new world now, a world where a 1990s type approach to airport expansion no longer has weight, a world where responsible growth is required by government as a condition of expansion, a world where, in order to expand, the aviation sector has to demonstrate that its activities will strike a fair balance, will share its benefits with those it affects, will ensure attainment of new climate change targets, and will minimise impacts. Turning then to the policy context, the APF and MBU do not provide unconditional support for the growth of airports. Mr Melling's approach of including in-principle support for growth in the planning balance as a freestanding benefit must be rejected. It is only where it's demonstrated that the benefits outweigh the costs that airport expansion obtains the weight of support from the APF and MBU. Where, however, the costs outweigh the benefits, then the APF and MBU weigh against the grant of planning permission. Whether the APF or MBU support or weigh against the grant of planning permission weight is to be given to them as material considerations in the Section 38.6 determination. There is no redundancy in this approach. It is a simple application of what Section 38.6 requires. It is a core principle of the APF that growth in aviation must strike a fair balance between negative impacts and positive impacts. That approach requires airports to share the benefits of expansion with the community surrounding airports. This is an applicable development control policy since it applies generally, and no reasons to depart from that policy have been proffered. The benefits of expansion must be demonstrated to be shared on a fair basis with those who bear the environmental impacts of expansion. Expansion which does not deliver a fair share of the benefits to those adversely affected is expansion which is contrary to the APF and MBU. Further, the APF expects noise levels to continue to reduce as airport capacity grows. This means that the expectation is that noise levels in the future with an expanded airport will not be worse than the present day. Indeed, as noise levels fall, airports are expected to share the benefit of these improvements with those who live around them. Turning to the core strategy, the Council recognises the potential for growth at the airport to benefit its area, but the potential for that growth is mediated through policy CS23 of the core strategy, which requires BAL to demonstrate the satisfactory resolution of environmental issues. Thus, just as at the national level, at the development plan level, there is no unqualified support for growth at the airport. The resolution of environmental issues pursuant to CS23 requires a qualitative assessment of the environmental impact, addressing whether the particular impact has been avoided or mitigated to a policy-compliant level. The same approach is adopted in linked policy DM50, and so in this way, policy CS23 does not operate on the basis of a simplistic balancing of harm and benefit. Rather, it is more demanding and targeted in its approach. Turning then to weight and policy, it's well established that as a matter of law, the weight to ascribe to policy is a matter for the decision maker, and we cite Tesco's there. Any policy can become out of date where undermined by a change in circumstances since adoption. That is the case even with national planning policy, and where policy is out of date, this reduces the weight that can rationally be ascribed to it. The Council submits that the APF and MBU are both out of date and to be given limited, if any, weight. Both of these policy documents were promulgated before the adoption by government of the 6th carbon budget, the net zero 2050 target, and before the decision to include international aviation within domestic targets. The Council's submissions in respect of climate change and MBU are not about what aviation policy should be in the future or should have been in the past. The submissions simply relate to whether there is evidence to support a view that the APF and MBU are up to date today. The submissions are not a full frontal attack on the merits of government policy, as BAL's claimed, but rather they entirely properly address the weight that you should ascribe to the APF and MBU in the Section 38.6 balance. The Bushell case is thus entirely beside the point, since it doesn't concern arguments relating to the weight to be given to adopted policy. You have to determine the weight to give to these policy statements as a matter of law. If those statements are out of date, then that is a material consideration in determining the weight to give to them. If you fail to have regard to whether they are up to date or not, then you will make an error of law. Only central government can undertake the exercise which is necessary to provide the cumulative impact context for decision making in relation to the aviation sector, since it is only central government that is able to form an overall view of the cumulative pathway to the attainment of the 6th carbon budget and net zero targets at a national level. The Council and the appellant agree that this is the case and that no other party can provide the necessary cumulative assessment. The exercise looking at compatibility of airport expansion with climate change targets contained in MBU is hopelessly out of date. MBU contains an assessment exercise which only looks at the compatibility of its approach with the previous 80% target. It sets out an appraisal which established that a particular level of airport expansion would be compatible with the achievement of the UK's previous climate change commitments. The planning assumption adopted of 37.5 megatons of CO2 was formulated by the CCC to achieve the 80% reduction in CO2 to 1990 levels. The assessment in MBU concluded that the policy support for the scale of expansion of airports which it envisaged would be consistent with the achievement of the UK's climate change commitments as they existed in 2018. But no similar exercises before this inquiry. The central government has not undertaken any concluded exercise which establishes that the policy support for airport expansion in the APF or MBU is consistent with ensuring the attainment of the 6 carbon budget and or the net zero 2050 targets, with the inclusion of carbon emissions from international aviation. Indeed, BAL does not contend that such an exercise exists, but rather accepts that it does not. Mr. Osen-Dyland agreed in cross-examination that the government has produced no concluded assessment which establishes that the policy approach set out in MBU is compatible with the attainment of the 6 carbon budget target or net zero 2050. The Jet Zero consultation cannot be relied upon as demonstrating that further airport expansion is compatible with the 6 carbon budget because it contains no assessment against the 6 carbon budget targets. Indeed, the government's not produced a sectoral target for the aviation sector. In the absence of one for the aviation sector, it's not possible to demonstrate that further airport expansion is compatible with the legal duty to ensure the attainment of the 6 carbon budget target. Further, Jet Zero is to be given limited weight in your considerations because it's a consultation paper. The consultation is not complete and it's highly controversial. Further, the assessment undertaken is inconsistent with the duty to ensure attainment of climate change targets. The consultation, of course, contains the footnote which states that MBU and the ANPS are the most up-to-date policy on planning for airport development. It said they continue to have full effect, for example, as a material consideration in decision-taking on applications for planning permission. The government is clear that expansion of any airport must meet its climate change obligations to be able to proceed. The wording is very carefully drafted. That this is so can be seen by the fact that these precise words were repeated by the DfT in its response to the Council's information requests. The words have full effect do not mean full weight. Whilst the Council recognises that the APF and MBU are the most recent policy statements made by government, that fact alone does not mean that the justification for the policy approach contained within those statements remains up to date. Rather, the Jet Zero paper footnote and the DfT response are careful not to state that the APF and MBU are up to date and do not do so. Neither footnote 39 or the DfT's response state that APF or MBU are to be given full weight, and that can be seen from the text above. The DfT has expressly stated that it's for the decision maker to determine the weight to be given to those documents. If the policy position was that the APF and or MBU are to be given full weight, then the DfT or government would say so in terms. The fact that they have not, but instead indicated that weight is for the decision maker, makes it clear that the DfT or government expresses no view on the question of weight. Accordingly, where footnote 39 states that the APF and MBU are of full effect, that is not a statement that those policy statements are up to date and to be given full weight. Rather, it's a statement that they remain adopted policy and are material considerations in the determination of an airport expansion proposal. Consequently, the APF and MBU are material considerations and to be given weight in the decision. However, the weight to be given to these policy statements is a matter for you. Other documents relied upon, including the Stansted decision, do not identify that APF and MBU are up to date in the light of the adoption of the 6 carbon budget targets, net zero target, and accordingly, and in any event, you have to consider and determine this issue yourselves. The Council submits that the evidence and submissions in the present case mean that the Stansted decision cannot be relied upon as establishing that MBU is up to date and to be given full weight. Indeed, we submit that to follow the Stansted inspector's approach would be to err in law. You have to base your decision on the evidence and submissions made in this case. The evidence and submissions provided in the Stansted inquiry are not before this inquiry. The evidence and submissions provided in the present inquiry result in a different conclusion. In this regard, it is also important to note that MBU examined whether the expansion of capacity by just 11.8 MPPA would be compatible with the 80% climate change target for 2050. It's been agreed in the present case that the total amount of identifiable expansion in the pipeline within the UK amounts to some 88 MPPA. There is no evidence that established that all of this development could come forward consistently with the attainment of the 6th carbon budget and net zero 2050 targets. Thus, the possibility that there will be insufficient carbon capacity to enable all these schemes to come forward cannot be ruled out. That means the need for a choice to be made by central government as to which schemes can come forward and which cannot be ruled out, as Mr. Osen-Ireland readily accepted in cross-examination. If there is uncertainty whether a grant of planning permission would be consistent with the attainment of the 6th carbon budget target or net zero 2050, it cannot be rationally concluded that granting planning permission would ensure attainment of these targets. As a result, if there is any uncertainty whether a grant of planning permission would be consistent with ensuring the attainment of the 6th carbon budget target or net zero 2050, a grant of planning permission would be contrary to the statutory duties to ensure attainment contained in Sections 1 and Section 4 of the Climate Change Act 2008 and would be unlawful. This is obviously the case, and it has been obvious since Bristol Airport Limited determined to pursue this appeal. To pursue an appeal for a planning permission that cannot lawfully be granted is manifestly unreasonable. Further, and in any event, a grant of planning permission now could prejudice the formulation of national policy in the sense that it predetermines which airports should expand prior to any comparative exercise that may be required being undertaken. Thus, the grant of planning permission is premature. That is a factor which must be given significant weight against the grant of planning permission in the determination of this appeal. The simple reality is that planning permission cannot be granted for the proposed development. Further, the APF and MBU are out of date and be given little, if any, weight to the extent that they support the expansion of airport capacity. If it is necessary to go further in the consideration of the implications of climate change, the central issue is whether, if planning permission is granted, the evidence demonstrates that compliance with the UK's climate change targets is ensured. BAL has not identified and cannot identify any assessment by central government which demonstrates that a policy of supporting airport expansion is compatible with ensuring the attainment of the 6th carbon budget target or net zero 2050. As explained above, there is no evidence that a policy of expansion of all airports is compatible with those targets. As a result, there is no evidence which establishes that all airports can expand consistent with the achievement of climate change targets, and the need to choose between airports cannot be ruled out. Further, the aviation sector will become more significant as an emitter of carbon over time. The extent of greenhouse gas removal capacity that can be ensured to be available as at the 6th carbon budget and as at 2050 is unknown. The proportion of that unknown amount of GGR capacity which it is cost effective to ascribe to the aviation sector as opposed to other sectors also competing for that capacity as at the 6th carbon budget and as at 2050 is also unknown. Further, the Secretary of State has acknowledged that the amount of carbon that the aviation sector will be allowed to emit is yet to be determined. You can see that in the letter relating to the review of the ANPS. Emissions trading does not provide the answer to the as the UK emissions trading scheme only runs to 2030 and CORSIA only runs to 2035. The evidence before this inquiry indicates that market-based measures cannot of themselves ensure attainment of carbon reduction targets, as Mr. Osen-Ireland agreed in cross-examination. Since the amount of emissions that the aviation sector will be allowed to emit consistent with climate change obligations is yet to be determined, BAL is unable to demonstrate that the scale of emissions related to the proposed development will not have a material impact on the UK's ability to meet climate change targets. This position isn't new. The position of the inspectors in the A38 Derby Junction scheme was analogous, and they were unable to conclude that the scheme they were considering was consistent with the attainment of climate change targets because they didn't have evidence before them to prove that a sector-wide appraisal they didn't have before them a sector-wide appraisal demonstrating that growth was consistent with climate change targets. Those inspectors were able to pass the difficulty on to the Secretary of State, but you cannot. Your only choice is to conclude that the proposed development is contrary to national aviation policy, contrary to the NPPF, and in particular the objectives in paragraphs 7 and 148, contrary to policy CS1 of the core strategy and the duties in the CCA 2008 to ensure attainment of climate change targets. So if you reject the submission that a grant of planning permission would be unlawful, these conflicts are substantial and must be given significant weight against the grant of planning permission. In terms of noise, BAL's approach to consideration of the noise impact seriously underestimates the impact of the proposed development upon the local community. Its proposed mitigation package is inadequate, ill thought out and reactive. Indeed, it is contrary to the approach required by the NPPF to minimise the adverse effects of noise. Further, BAL fails to deliver anything close to the fair balance between the negative impacts of noise and the positive benefits to those living around the airport that national aviation policy requires. Indeed, it visits only harm upon them without providing any economic benefit to them whatsoever. Thus, it's the very antithesis of the approach to fair sharing required by national aviation policy. The proposed development will have wide-ranging and significant adverse impacts upon many thousands of people, including widespread sleep disturbance impacts. It will impinge upon the quality of life for many thousands, inhibiting the use of their homes and gardens in a substantial way. The proposed development is contrary to policy CS3, CS23, CS26, the NPPF and national aviation policy as a result of these impacts, which weigh very substantially against the grant of planning permission. The proposed development will consume the noise reductions that would otherwise be experienced if planning permission were refused compared to the baseline of 2017. Indeed, the noise at night will increase to the extent that at least some 7,000 extra people will suffer significant adverse noise impacts compared to the position in 2017. This is not an airport expansion which delivers the noise improvement as envisaged by national aviation policy. This is a development which delivers a material reduction in the noise environment which was already adversely affected by the operation of the airport. When the consequences of what is proposed are examined, it is little wonder then that the community living around the airport express the views heard at this inquiry, which are critical of BAL's warm words of community involvement and engagement. Mr. Williams's evidence demonstrates beyond peradventure that those words are hollow. There is no sharing of anticipated reduction. Rather, the proposed development removes almost entirely any improvement that would otherwise be delivered from technological improvement. There is no sharing of the benefits in a fairer way than in the past, as the core principles of the APF expect. There is no fair balance struck here. The local community does not get a fair share. Rather, it gets no share at all, since BAL seeks to take everything for itself. The noise impact assessment conducted by BAL and the ES and ESA significantly underestimates the nature of the noise impacts of the proposed development on the local community for a host of reasons. In particular, it adopted an approach of relying solely on LAEQ-based metrics, which are recognised by both government and ICANN as failing to reflect all aspects of the perception of aircraft noise, especially that such metrics are insensitive to the changes in a number of events. Mr. Fumicelli was therefore supported in his position by government and by ICANN in stating that other indices had to be utilised, particularly the number above index. There is no primary noise index, rather all indices need to be examined in the round. The adoption by BAL of significance criteria solely related to the change in LAQ was flawed and has been rejected in the past as failing to reflect people's perception of aircraft noise when the number of events changes. Research demonstrates that in real life, each airport movement even if undertaken by a less noisy aircraft, will still be perceived as a noisy event and will not be valued by the local community as being quieter. Thus, people affected by the development will notice the increase in the number of flights more than they will find value in the comparatively small reduction in noise from each new generation aircraft. Utilising a change in exposure to LAQ as the basis for assessing significance is also inconsistent with the policy approach by the MPPF and MPSE. These documents require an approach whereby acceptability of noise is examined against absolute levels derived by reference to dose-response research. Where a receptor is already experiencing residual noise levels above SOL, there is a danger in adopting a criterion of acceptability which is based simply upon a change in noise. The danger is that such a criteria may identify an impact as insignificant, when in fact a development adds to noise levels experienced at the receptor which are already above SOL and thus already experiencing a level of noise which is so significant that it should be avoided. An assessment methodology which simply determines that a small incremental change at such a receptor is insignificant fails to reflect the policy approach in the MPPF, that a development which adds to a noise environment already above SOL will result in a noise environment even more above SOL, which is to be avoided. That is because it adds to a noise environment for that receptor which is already at a level which causes significantly adverse effects upon health and quality of life and simply makes the position worse. It simply adds noise to an environment which is already eroded beyond a level that is acceptable in policy terms. And so a development which increases noise levels which are already above SOL, it is a development which is to be avoided. It is not a development which has no significant impact. Accordingly, the methodology utilised in the ES-ESA identifies as insignificant adverse impacts which the MPPF considers it necessary to avoid. Accordingly, a conclusion in the ES and ESA that an impact is not significant does not mean that there is no breach of the MPPF. The ES and ESA methodology cannot be used to assess compliance with the MPPF. Noise above SOL is described in the noise hierarchy as noise that causes a material change in behaviour, attitude or other physiological response. For example, avoiding certain activities during periods of intrusion where there's no alternative ventilation, having to keep windows closed most of the time because of the noise, potential for sleep disturbance resulting in difficulty in getting to sleep, premature awakening and difficulty in getting back to sleep. Quality of life diminished due to change in acoustic character of the area. This means that you're free to review the evidence before you to consider all the relevant noise indices, the likely impacts of the proposed development by reference to those indices, and the implication of those impacts as identified by all relevant noise indices upon health and quality of life, and whether those implications reveal impacts which are above LOL and or at or above SOL. Determining what is LOL and what is SOL is a matter of for you to be determined on the basis of the facts in this case. Mr. Fumicelli explained to this inquiry that there's strong evidence that attitudes to aircraft noise have changed over time. He pointed to the most recent WHO noise guidelines. He also referred to the SONA 2021 sleep disturbance study, which demonstrates that a much higher percentage of people are highly sleep disturbed than has previously been recognised. He also referred to the need to take into account the nature of the rural area in which the area is situated, a factor of importance when considering sleep disturbance, according to the WHO guidelines and the ICANN report. This distinguishes Bristol Airport from other airports, and it means that Mr. Fumicelli's identification of SOL at night as 50 dB LAQ 8-hour is entirely appropriate in this case. The ICANN report explained that the number above index reflects key aspects of aviation noise that are not covered by LAQ-based metrics. It can be used for forecasting, and the number of events is an important aspect of noise exposure, and thus the number above index is more likely to be reflective of aviation noise and the annoyance that it causes than the LA max index, which only looks at the maximum level of noise. Recent evidence in the SONA 2021 study demonstrates that the N60 index correlates well with nighttime self-reported sleep disturbance, as well as correlates as well as the LAQ 8-hour index. In summary, The results for the N70 index, that's the daytime index, demonstrate that widespread speech disturbance will be caused to people in their houses, even with their windows shut. Over 1,100 extra people will be subject to N70 levels between 100 to 199 times a day. They will avoid using their gardens. They will have to keep their windows closed to talk to members of their household, to use the telephone or to watch television. They will have to live their lives with windows shut most of the time, and even then their quality of life will be significantly adversely affected. You've heard local people describe precisely these sorts of impacts already occurring for many. That level of exposure will result in material changes in behaviour. A large number of residents' lives will be diminished by the acoustic character of the area changing because of the airport's operations. They will experience a level of noise above soul, which is not mitigated, as Mr. Williams agreed in cross-examination. However, it is at night when the N60 index really reveals the true extent of the impacts of the proposed development. If planning permission is granted, an additional 3,050 dwellings will be subject to 20 to 49 noise events of 60 dB LAS max or above, compared to the position if permission is refused. That's some 7,000 people. With the window partially open, they will suffer noise levels of 47 to 48 dB LAF max, 20 to 49 times per night. That is a level considerably above the WHO guidelines threshold of 45 dB LAF max, 10 to 15 times per night, which is the threshold for sleep disturbance. To avoid sleep disturbance, all of these people will have to have their windows closed for most of the time. However, only 250 houses, some 575 people, qualify for noise mitigation as a result of impacts at night. That leaves some 6,500 people suffering potential impact resulting in sleep disturbance and without mitigation, unable to sleep with the windows open, but unable to close them in summer because BAL doesn't provide what is necessary for them to have an appropriately noise-insulated and ventilated bedroom. Indeed, it's possible to calculate by reference to the SONA 21 report that 1,038 people from this group will self-report as highly sleep disturbed in the light of the N60 information. Again, substantially above the number of people who qualify for noise mitigation under BAL's scheme for impacts at night. The proposed development will leave hundreds of people sleep disturbed and thousands without any mitigation suffering levels above SOL. That is a significant adverse impact which needs to be weighed heavily in the balance against the grant of planning permission. The mitigation proposed does not result in impacts above SOL being avoided and is contrary to policy. The mitigation is also contrary to policy because no mitigation at all is offered to anyone in the bracket between Lowell and SOL. Not one household, not one person out of thousands falling within this bracket. But the applicable MPPF policy is clear. The noise visited on these people must be reduced to a minimum by adopting all reasonable mitigation. Since none is offered, there is a clear breach of national policy. The noise mitigation scheme which is offered is too limited in extent, parsimonious, and is unjustified by reference to any evidence. There's no evidence, no cost appraisal, no evidence from past works, nothing before this inquiry that demonstrates that the proposed mitigation scheme provides sufficient funds to reduce noise impacts within homes to acceptable levels. Accordingly, the proposed development is contrary to CS3 and CS23 of the core strategy, since the impacts have not been resolved and remain unmitigated. The impacts are of a scale and nature which means that they will cause harm to the health of those impacted, and as we shall explain, those people do not receive any compensatory health benefit. Thus, the proposal is also contrary to policy CS26 of the core strategy. Though the noise impacts weigh very heavily indeed against the grant of planning permission in this as a result of breaches of national aviation policy, national planning policy and the development plan, and these are factors to be given very significant weight in the planning balance against the grant of planning permission. Further, there is uncertainty in the forecasting process, since it's dependent upon the appraisal of a single fleet mix. There are no guarantees that the fleet mix assessed will in fact materialise. Indeed, in cross-examination, Mr. Brass agreed that there is no single correct fleet mix. The Jacobs fleet mix demonstrates that it's necessary to impose controls over the type and number of aircraft using the airport in future in order to constrain the noise impacts of the proposed development. It establishes that without constraint, noise impacts could be markedly different from those which have been assessed in the ES or the ESA. It has to remember that planning conditions cannot be imposed simply because the local planning authority and applicant agree. They have to be justified as necessary by reference to evidence. At an appeal, a local planning authority has to justify the conclusions which it seeks to the decision maker. As a result of the fleet mix, the Council has established that without appropriate controls imposed in relation to a contour cap and indeed an ATM's limit, there is a realistic prospect that a grant of planning permission would give rise to noise impacts which are materially greater than those which have been assessed in BAL's evidence. Accordingly, the fleet mix evidence justifies the imposition of the controls proposed in terms of the mitigation of impacts, including the ATM's limit, which BAL disputes. The noise contour condition proposed by BAL is insufficient to hold the airport to the likely significant impacts as set out in the ESA, and it must be rejected, or its imposition will lead to an error of law. The Council's condition, which applies the contours from BAL's ES and ESA, is to be preferred. For the noise conditions proposed to be enforceable by BAL, the airport must become coordinated. This does not present any barrier in terms of the development coming forward on the basis of the evidence. If a gramping condition is not imposed, then the noise conditions will not be enforceable, and that means that the proposed development is entirely unacceptable. These controls are all necessary. Accordingly, if you consider that you cannot impose the gramping condition requiring coordinated status prior to the commencement of development, you must refuse planning permission. Turning to air quality, Bristol Airport Limited has adopted entirely the wrong approach to the assessment of air quality impacts from the outset of its application. Consistent with aviation policy and the approach within the 2010 Air Quality Standards regulations, there's a requirement for airport expansion schemes to go beyond mere compliance with adopted UK air quality objectives. The growth of airports is intended to be delivered by reference to the achievement of improvements in air quality through the adoption of ambitious targets and action plans. The appeal proposals were never approached this way. There was no attempt to design the scheme from the outset so as to deliver improvement in air quality. The fact that no air quality action plan has even been produced, even for the purposes of this inquiry, demonstrates the disdain with which BAL has approached this topic. This is notwithstanding the existence of considerable evidence demonstrating that adverse health impacts arise at levels below the UK air quality objective levels, nor the evident risk that their proposals would harm the health of those living around the airport. That the proposed development will harm the health of those living around the airport is now confirmed by the publication of the latest international benchmark, the WHO Air Quality Guidelines. When measured against the WHO Air Quality Guidelines, the only conclusion that can be reached is that the proposed development will give rise to an increase in important risks to public health compared to the position if planning permission were refused. In other words, the baseline presents important risks to public health, which the grant of planning permission for the proposed development will make worse. A reworking of BAL's own methodology against the WHO air quality guidelines demonstrates widespread moderate impacts and widespread substantial impacts associated with exposure to nitrogen dioxide, PM10 and PM2.5. It's notable that BAL's note for information on the new WHO air quality guidelines contains no evidence-based reassessment of potential impacts, but instead simply states without foundation that the appeal proposal is likely to contribute to improving health and well-being of the local population more than it detracts from it. Very little weight should be attached to this assertion. Rather, the conclusion that must be reached by reference to the WHO Air Quality Guidelines 2021, that the proposed development will give rise to important risks to public health, is entirely aligned with the approach identified by Dr. Broomfield in his evidence. But that conclusion is entirely contrary to the approach adopted by Mr. Pearson BAL, which focused almost entirely on the question of compliance with existing limit values. After all, the environmental statement identifies the air quality impacts as insignificance. That is a total failure to acknowledge adverse impacts upon public health of a scale which the WHO identifies as an important. An impact which is important must be an impact which is significant. Existing limit values were not formulated against the background of the advances in scientific knowledge over the last decade and are not consistent with the new international benchmark WHO air quality guidelines. BAL's assessment in its identification of the degree of harm must be rejected. As a result, it must be concluded that the proposed development would give rise to an increase in important adverse risks to health of those living around the airport, which have not been demonstrated to be mitigated to acceptable levels. Accordingly, for the reasons explained above, the proposed development is contrary to national aviation policy, the MPPF, and policies CS3, CS23 and CS26 of the core strategy, and this must be given significant weight in the balance against the grant of planning permission. Turning to health impacts, the health impact assessment is flawed because it did not assess the health impacts as required by policy CS26. That policy requires it to be demonstrated that large-scale development will result in improvement to the health and well-being of the local population, in other words, those living around the airport. Mr. Piper's assessment didn't undertake this exercise and was based on a flawed methodology which did not accord with good practice, and in respect of which it was entirely impossible to understand how he reached the judgments as to significance that he did. It was also reliant upon the ES and ESA conclusions that noise impacts and air quality impacts were not significant. As we've explained, the opposite conclusions should be reached. Further, Mr. Piper did not assess impacts and benefits by reference to the same spatial extent. His health impacts were assessed at the North Somerset level, whereas his benefits were assessed at the South West and South Wales level. There's no examination of the relative effects on health that come in the with and without development scenarios at the South West and South Wales level. Accordingly, there's no reliable evidence of significant net beneficial health impacts arising if planning permission were granted compared to the position if planning permission were refused. For example, someone living in greater poverty in South Wales who obtains a job if planning permission is refused may obtain a greater health benefit than somebody living in the more affluent areas around North Somerset would if planning permission were granted. There's nothing in Mr. Piper's assessment which demonstrates that this relative effect has even been considered. To conclude, the proposed development is contrary to the APF, Aviation 2050, the MPPF, Policy CS3 and 26, and the breaches of policy here weigh heavily against the grant of permission. The wider health impacts of the proposed development are at best neutral. Surface access, this issue cuts across the first, fourth and fifth reasons for refusal, and in summary the Council submits that BAL has not demonstrated that the proposed surface access infrastructure is adequate. To the contrary, the Council's evidence demonstrates that there are material unresolved issues with the proposed infrastructure. BAL has failed to demonstrate that its claimed level of parking is actually required. The updated parking demand survey is not robust, does not justify the claimed level of parking demand, and should be afforded no weight. BAL has failed to demonstrate that its proposed 2.5% increase in public transport mode share is ambitious. To the contrary, the Council's evidence demonstrates that at least a 5% increase in PTMS could be achieved. Turning to public transport mode share, there's a clear imperative to maximise PTMS by setting ambitious targets. It's recognised by Aviation 2050 that there's a need for airports to deliver more ambitious mode share targets, and the government expects airports to make the most of their regional influence to provide innovative solutions and incentives against ambitious targets which reduce carbon and congestion and improve air quality. This is consistent with the APF. Similarly, the NPPF requires that transport issues should be considered from the earliest stages, so that, amongst other things, opportunities to promote walking, cycling and public transport use are identified and pursued. In addition, the NPPF requires that appropriate opportunities to promote sustainable transport modes can be or have been taken up. The same approach is reflected in CS1, CS10, DM26 and DM50. The starting point is to recognise that the proposed development has not been designed from the outset, from the earlier stages in the language of the NPPF, to deliver an ambitious PTMS. BAL has applied on the basis that it would simply maintain the 15% PTMS which it had already promised under the 10 MPPA planning permission. In other words, its position was that no public transport mode share uplift would be provided. So the development was never designed to maximise PTMS or to achieve an ambitious target. To the contrary, it was devoid of any ambition and simply sought to roll over the status quo. The deficiencies in the preparation of the application, the TA and the ESA, have not been cured in Mr Witchell's evidence to this inquiry. In his proof of evidence, Mr Witchell's attempted to justify the 2.5% retrospectively. This assessment does not assist Bell for the following reasons. Firstly, Mr Witchell's evidence does not undertake the correct exercise in order to establish that a 2.5% uplift is ambitious. It's necessary to establish what is possible and the difficulty of attaining different levels of uplift. Mr Witchell's exercise doesn't do this. Rather, the assessment simply takes some, not all, of the proposed measures and seeks to understand what sort of uplift those measures could achieve. This does not establish what the maximum uplift it is possible to achieve. Secondly, even if Mr Witchell's exercise was the correct one, it doesn't represent a complete assessment because there are a range of proposed measures which are not assessed. Thirdly, even on Mr Witchell's own results, a public transport mode share increase of 2.5% is not ambitious. His assessment indicates an improvement of at least 2.9% or 4.1% is possible. There's no good reason to discount this conclusion to 2.9% or 4.1%. Mr Collins' evidence was that a public transport mode share increase of at least 5% should be targeted. The challenge to this in cross-examination was limited. It was put to Mr Collins that this figure was unevidenced, but that omits to consider Mr Collins' reasoning on Mr Witchell's own evidence. The 2.9 or 4.1% PTMS increase is achievable from only some of the measures proposed by BAL. Thus, when the full range of proposed measures are included, a greater uplift in public transport mode share will be achieved and a PTMS of 5% is realistic. Further, Mr Collins was challenged on the basis that if a target of 5% uplift was set, it may not be met. Leaving aside the fact that the evidence does not show this, even if the target was missed, that does not demonstrate that the target's inappropriate. There are many reasons why it could be missed, and the appropriate response in those circumstances is to revise the ASAS to include further or improved measures to achieve the uplift. That can only be a good thing. The more people on public transport, the better. Moreover, it's an approach which is possible. Recall again Mr Witchell's evidence in cross-examination that there was no ceiling to the airport's public transport mode share. In the light of the above, the Council submits that the proposed development fails to comply with national or local policy on public transport. In particular, the proposed development is not in accordance with policies CS1 and CS10 of the core strategy or the MPPF paragraphs 104 and 110, and the fifth reason for refusal is made out. This is a matter to which very significant weight against the grant of planning permission should be given in light of the clear requirement for ambitious public transport mode shares in national aviation policy, which resounds in the MPPF and local policy. Turning to parking demand, the Council submits that the UPDS fails to provide any basis, let alone a robust basis, for concluding that the claimed parking demand is accurate. There are three principal and independent reasons for this. First, the calculations underpinning the claimed demand have not been scrutinised and can be afforded no weight. Despite the UPDS seeking to reflect a higher level of public transport mode share, in other words, the 2.5% uplift to the 10 MPPA baseline, than the PDS, 15%, in other words, the 10 MPPA baseline, the output of the UPDS actually shows a need for more car parking spaces, not fewer. The PDS predicts a need for 21,900 spaces, the UPDS a need for 22,200. By comparing the steps in the methodology in the PDS and the UPDS, it can be seen that this discrepancy is a result of the occupancy to demand ratio. This is apparent because in the UPDS, the OD ratio is applied to a lower number of total cars parking at the airport each year, see step 4, than in the PDS, yet despite this lower starting point in the UPDS, a greater peak demand results. However, the operation of the OD ratio, as well as a number of other inputs in the PDS and UPDS, is entirely opaque. This could not be scrutinised by the Council. As a result, the clear anomaly has not been explored or explained. This opaqueness exists despite requests from the Council for further information. The refusal to allow scrutiny on the basis of commercial confidentiality means that no view on the robustness of the UPDS can be reached. The Council has been denied the opportunity to present evidence as to the robustness of the UPDS by BAL. the consequence is that no independent party to the inquiry can reach a view on the robustness of the model, and if you were to give it any weight, unfairness would arise. Secondly, the UPDS has applied the 2.5% PTMS increase to the wrong baseline. It is an agreed position that the 2.5% PTMS increase needs to be applied to a baseline which represents the PTMS required of the 10 MPPA permission, i.e. 2.5% on top of the 15% public transport mode share measured by bus ticket data, which is secured in the 10 MPPA Section 106 agreement, and Mr. Witchells confirmed that at the very start of his cross-examination. However, the UPDS does not apply the 2% increase to a baseline which reflects the 10 MPPA baseline. Put another way, the 2.5% PTMS increase is not applied to the correct starting point. It is apparent from this, and as Mr. Witchells confirmed in cross-examination in any event, that the 2.5% uplift was applied to the CAA figure of 21.8% directly. There was no process of rebasing, and the bus data was not used. This approach is only robust if the 21.8% CAA figure is equal to or greater than the 10 MPPA baseline. However, there is no evidence that this is the case. Mr. Witchells accepted in cross-examination that the comparative exercise, the rebasing, had not occurred, and when pressed as to whether the CAA 21.8% figure was the same as, above or below the 10 MPPA baseline figure of 15% measured by bus ticket data, he simply did not know. It follows that there's no rational basis for concluding that the 2.5% public transport mode share uplift has been applied to the correct baseline figure, reflecting the 10 MPPA Section 106 agreement baseline which has to be used. In fact, there are other parts of Bow's evidence which positively suggest that the 21.8% CAA figure is not equal to or greater than the 10 MPPA baseline. Mr. Melling's written evidence is that the PTMS measured by bus ticket data is 13.8% as at 2019 against a 10 MPPA target of 15%. Taking that at face value, the 21.9% figure used by Mr. Witchells was not equivalent to the 10 MPPA baseline, rather it was below it. It follows that the PTMS uplift calculated from that figure was too low. The PTMS in the UPDS should have been a higher figure, with the inevitable result that the parking demand would be lower. This confirms the fact that the UPDS can be afforded no weight. Thirdly, if the Council is correct that the proposed public transport mode share of increase of 2.5% is not policy compliant, and a higher public transport mode share increase, for example 5%, is policy compliant, it follows that the UPDS is premised on an inaccurate input because it only considered an increase of 2.5% and not a greater one. Against the inevitable consequence of a greater increase in PTMS, the consequence is that the demand for car parking will be lower, and so it follows that the claimed parking demand is not justified without more. For any or all of the reasons I've just explained, the UPDS should be afforded no weight, and the claimed demand for on-airport parking has not been demonstrated. Turning then to surface access infrastructure, the specific issues with each junction set out in Appendix A of the closing submissions, and for the reasons set out in that appendix, the mitigation proposed by BAL is inadequate because it would give rise to adverse impacts on highway safety and severe residual cumulative impacts on critical junctions near the airport. On numerous occasions, both in his written and oral evidence, Mr. Witchells accepted that there was a deficiency in the proposed junction design, but his response was simply to suggest that it would be dealt with by way of amendment in the detailed design of the junction. The realism and consequences of those amendments are dealt with in Appendix A. However, as a matter of principle, this response is inadequate. The highway aspects of this scheme are not reserved matters, rather detailed planning permission is sought. Pursuant to proposed condition 3, the proposed development must be constructed in accordance with the approved plans, including the plans showing the junction improvements. Even if proposed condition 3 did not require compliance with the approved plans, Nevertheless, the junctions would need to be constructed in accordance with them, and that's because the law has moved on from the practice of the past so that it now inhibits ad hoc and informal deviation from approved drawings, and we've cited some authorities in more detail in the closing submissions to support that submission. It follows that junction design cannot simply be changed in some detailed design process after the grant of planning permission. The junction must be constructed as is shown in the approved plan. It follows that the proposed development is not in accordance with National Aviation Policy, the NPPF, particularly Para 110, or Policy CS3 of the core strategy. This factor should attract significant weight against the proposed development in the planning balance, given the clear conflict with the recurrent policy imperative to improve surface access, including infrastructure to the airport, and to avoid adverse effects on existing infrastructure. The green belt. This issue embraces the fourth reason for refusal, and in summary, the Council submits that the year-round use of the existing Silver Zone car park and the Silver Zone extensions proposed amounts to inappropriate development in the green belt. The Silver Zone development will cause significant harm to the openness of the green belt, and there are no other considerations which clearly outweigh the harm to the green belt, which must be afforded significant weight in accordance with the NPPF and the other harm resulting from the proposed development, and thus very special circumstances have not been demonstrated. It has become apparent that Bowell's case, and Mr Melling's evidence in particular, has not been advanced on the basis of a correct interpretation and application of the NPPF. Bowell failed to recognise that spatial harm to openness can result even when there is no or limited visual impact. Mr Melling also struggled to understand that substantial weight is the starting point when ascribing weight to harm by reason of inappropriateness and to the openness of the green belt. Further, he did not realise that very special circumstances are the outcome of a balancing exercise, not a freestanding set of factors which the airport can cross out every time it wishes to develop in the green belt. Turning to harm to the green belt, it's agreed that the year-round use of the existing Silver Zone car park and the Silver Zone extension amounts to inappropriate development in the green belt. The Council submits that that will cause significant harm to the openness, and that's the case even on Mr Melling's own methodology. Taken together, the Council submits that both Cog Loop 1 and Cog Loop 2 contribute to the purposes of including land in the green belt. In particular, Cog Loop 2 makes an important contribution to safeguarding the countryside from encroachment. Further, there's a high degree of spatial and visual openness to Cog Loop 2 at all times, and in winter, the openness of Cog Loop 1 is materially higher than when it's in use during the summer months. It's well established through multiple appeal decisions in the Council's area that the block parking of car results at least in spatial harm to the green belt. The Council submits that the introduction of block car parking onto the existing Silver Zone car park and the Silver Zone extension will have a stark and significant spatial impact. Mr Gertler's unchallenged evidence was that the Silver Zone development covers an area of 12.9 hectares, with Cog Loop 1 extending to 7.8 hectares, Cog Loop 2 extending to 5.1. Further, under the Silver Zone development, 6,350 cars will be block parked, with 3,650 on Cog Loop 1 and 2,700 on Cog Loop 2. Those 2,700 will cover 3.73 hectares on Cog Loop 2, in other words, 73% of its area. Having regard to the extent of the block parking, there will be a significant permanent spatial effect on the openness of the green belt. Cog Loop 1 will be affected during the winter period when it is presently free of cars and without vertical built form, because the lighting and CCTV is temporary, thus rendering harm to the openness of the green belt permanent. Cog Loop 2 will be affected year-round. An entirely open agricultural field will be transformed with built development, lighting poles, CCTV poles, fencing, asphalt, as well as the block parking. This effect will be permanent and stark, as Mr Melling accepted in cross-examination. Moreover, these spatial effects cannot be mitigated, as Mr Melling also accepted in cross-examination. The starting point is that Bowell does not contend that there is no harm to the visual aspect of openness. Accordingly, the dispute between the parties is the extent of the harm. The Council submits that Mr Melling's assessment of the visual impact is an understatement. His reliance on the LVIA causes his assessment to be one which misses the target. It is an assessment of particular views and visual effects, but not of the visual aspects of openness. In addition, Mr. Melling's evidence failed to take proper account of the effects of lighting on the visual aspects of openness, and ultimately, free of that erroneous approach, it is clear that there will be adverse effects on visual openness, and whilst there are potential opportunities for mitigation, the nature of the mitigation proposed is unlikely to be acceptable, as it will itself shorten views, increase the sense of enclosure, and thus exacerbate the harm to the openness of the greenbelt. Moreover, the silver zone development will result in additional traffic generation. There will be traffic on Cog Loop 1 throughout the year as opposed to just the summer months at present, and there will be a significant increase in traffic on Cog Loop 2 where there is none at present. All of these effects will be permanent and will not be remediated. The Council submits that the silver zone development also conflicts with the purposes of including land in the greenbelt, namely the purpose of safeguarding countryside from encroachment. As set out above, Cog Loop 1 and 2 both assist in safeguarding the countryside from encroachment. The silver zone development runs directly contrary to that purpose, increasing car parking in the greenbelt, and is another example of the creeping encroachment which has characterised the development of the airport, as we explained in opening. The encroachment is particularly stark in respect of Cog Loop 2. That is the most important parcel in preventing the sprawl of the airport, yet that parcel will be lost to the silver zone development. For the reasons above, the silver zone development will give rise to significant harm to the openness of the greenbelt and will conflict with the purposes of including land within the greenbelt. It's notable that the Council's officers also concluded that there would be significant harm to openness of the greenbelt. Turning to the next section, which we've entitled No Very Special Circumstances, as we've already explained, Bell's not demonstrated its claimed parking demand. On this basis, the first factor advanced by Bell in its very special circumstances case has not been made out. Given it is the parking which drives the development in the greenbelt, this is dispositive of both the VSC balance and, given the clear terms of national policy, the planning balance overall, as we've set out. Moreover, it's not good enough to simply assert that there will be some unspecified increase in parking demand. Bell must demonstrate, but has not demonstrated, the need for the entirety of the claimed parking demand. For the avoidance of doubt, such uncertainty as there is not cured by the monitor and manage condition or any obligation in the Section 106 agreement or unilateral undertaking. Bell's proposed monitor and manage condition simply requires the submission of a report. It does not and cannot, as a matter of principle, provide any mechanism by which the Council can restrict the extent of parking in the greenbelt, because once granted, the Council cannot go back on the principle of the development. Moreover, it cannot cut across the phasing, which is deficient for reasons that we've explained. In any event, the monitor and manage approach proposed by Bell demonstrates that the uncertainty in Bell's forecast demand makes good the Council's position. Monitor and manage is advanced on the basis that there may be a change in circumstances which results in a lower level of demand. For example, Mr. Melling states that the demand for car parking for specific products may change over time. And he highlights inter alia that matters such as shifting travel behaviours, technological innovation and customer preference. On this basis, Mr. Melling contends that the monitor and manage approach will ensure that additional parking is only brought forward when the demand for spaces arises. As is clear from Mr. Melling's evidence, the monitor and manage condition is only proposed because it is not certain today that all of the proposed parking spaces will be required. If it was otherwise, and there was certainty today that all the proposed parking spaces were necessary, the monitor and manage condition would not be necessary and thus couldn't be imposed lawfully. The principal argument advanced by Bell for providing the silver zone development and for providing it in advance of the MSCP3 is the claimed need to provide low-cost parking via surface parking. This argument is unsound for the following reasons. Firstly, Bell's presented no viability evidence, or even basic evidence on costs, income, profit levels, to demonstrate that MSCP could not be constructed and used for low-cost parking. Without this evidence, it would be irrational to conclude that MSEP car parking could not be used for low-cost parking on the basis of construction costs or commercial considerations. Secondly, BAL's claimed competition risk does not withstand scrutiny. The legal advice note provided is given on the basis that BAL is required by the Council or the Secretary of State to provide low-cost car parking in the MSCPs. This is no answer to the Council's case. The Council's case is different and much simpler. If BAL wants to use the multi-storey car parks for low-cost parking, it can do so. That doesn't pose any competition or risk because no requirement would be imposed on BAL and there would be no anti-competitive agreement. Further, even if low-cost car parking in the MSCP could not be provided without cross-subsidy from commercial revenues, for example duty-free concessions and the like, which is not accepted, this would pose no competition or risk. It would be entirely lawful for such revenue streams to be used as a cross-subsidy. Contrary to the suggestion in re-examination of Mr. Melling, the advice note simply does not deal with the issue of cross-subsidy. In the light of the fact that there is no cost or price-based justification for the Silver Zone development, this issue does not form a reason to discount the provision of further multi-storey car parks in the Greenbelt inset in order to meet parking demand. We turn now to deal with the alleged benefits of the proposed development before dealing with the planning and Greenbelt balances. Turning then to benefits. It's submitted that when considering the benefits of the proposed development, the weight is given only to the net benefits of granting planning permission, in other words, to the benefits that will only be delivered if planning permission is granted. This requires the identification of the net benefits of development, and looked at in this way, the net benefits vary depending on the geographic scope of the assessment. We'll return to that further below. Carbon values first. Past statements by government recognising the economic benefit that the aviation sector brings to the UK were made in the world prior to the commitment to ensure achievement of the 6 carbon budget targets and the net zero 2050 targets. That commitment brings with it significant carbon abatement costs. These are apparent from the new values of carbon identified by the DBEIS, which are to be used in economic and policy appraisals, and which change the approach with regard to the use of traded prices and non-traded values of carbon. Going forward, a single non-traded carbon value is to be used because it can be assumed that the traded sector will be managed to ensure that the sector pays for its emissions on an equal basis to the non-traded sector. Accordingly, since the expansion of the airport increases greenhouse gas emissions, they are required to be quantified and monetised using the new DBEIS non-traded carbon values. The cost of abatement reduces the economic benefits because the development will give rise to carbon emissions which will have to be abated in order to attain the climate change targets. In CD 2.8, BAL indicated that the NPV benefits of expansion were 1.565 million at the time of the original planning application. That decreased to 820 million in CD 222 at the beginning of this inquiry, and with the latest change in the price of carbons, these benefits are now stated to be 502 million. That is, the economic benefits of the scheme as calculated by BAL have declined by over 2/3 since the original planning application was submitted. Further, that NPV figure is calculated over a 60-year period. It's thus equivalent to less than £10 million a year in terms of benefit. As we shall see, this is about 1/10 of the increase of the costs of outbound tourism. BAL's contention that the cost of carbon should be excluded from the economic analysis is flawed. BAL has appraised the economic impact of the proposed development at 3 geographic levels: North Somerset, West of England and South West and South Wales. It has not appraised the impact of the proposed development on the UK, since of course there'd be a very low level of additionality from airport expansion if the net impact were assessed on that geographic scale. BAL has not assessed the economic impact at a European or global scale. As Mr. Ciro explained, it is crucial to include in the assessment the economic costs of carbon emission where these arise within the spatial area being assessed. There are additional carbon costs within North Somerset, West of England and South South West and South Wales area if planning permission is granted, which have to be taken into account. Similarly, the contention that the modelling of future airfares includes carbon costs associated with flights must be rejected. As Mr. Ciro explained, this conflates the impact of financial prices and economic costs. The traded price of carbon has been included in the airfare, leading to higher prices and hence a marginal reduction in demand. This marginal reduction in demand does not prevent the airport reaching 12 MPPA. The social economic cost benefit analysis presents the economic impacts over a 60-year period, and over that period there is an annual economic cost associated with carbon emissions of the additional flights arising from raising capacity from 10 to 12 MPPA. As stated by Mr. Ciro in cross-examination, these economic costs of carbon need to be included in the assessment. The situation is analogous to fuel duty being paid by motorists, which leads to a reduced demand for road travel, but the economic cost of additional carbon emissions is nevertheless still required to be and is captured in the economic appraisal of road schemes. Hence, the addition of carbon costs does not result in any double counting of carbon in the assessment undertaken by the appellant. Indeed, to adopt the view that there would be double counting would result in a failure to have regard to these additional carbon costs, which are an important material consideration. To omit to take them into account would give rise to an error of law. The economic benefits must be assessed by making the reduction that we've described. The MPV benefits of the scheme then, on BAL's own evidence, are some 500 million, 2/3 of what they originally claimed them to be. That is a very significant reduction in the level of benefit indeed. Business travel. BAL has significantly overestimated the economic benefits associated with the growth of business travel if planning permission is granted compared to the position if planning permission is refused. Mr. Brass's demand elasticity was based on the patterns of the past, which do not reflect the post-COVID world. The government has already recognised that in decarbonising transport, in the Jet Zero consultation paper, and in the Secretary of State's decision not to review the AMPS. The Secretary of State has accepted that there is no evidence that the previous relationship between demand and its drivers remains valid. As York Aviation itself has identified, the key trend in business travel is for companies to focus on reducing and, where possible, eliminating unnecessary air travel in order to reduce costs, maximising efficiencies and demonstrate corporate responsibility in the context of the climate change emergency. The upskilling of the entire workforce presents major opportunities to reduce business travel in the future, and these opportunities will be taken. Mr. Brass's scale of net growth in business passengers is greater than that which happened in the past and is unrealistic. Analysis of past data reveals that there is no representative evidence relating to past growth that can be reliably used to compare with the output of Mr. Brass's model. With Jet 2 coming to the airport, the percentage of leisure travel is only likely to rise, and there's no evidence that the level of 3% growth in business passengers per annum is realistic or likely to occur. However, there's a far more fundamental issue with the evidence presented regarding business travel. BAL has not proven that there would in fact be any net growth in business travel if planning permission is granted for the proposed development compared to the position if it were refused. As Mr. Ciro explained in his evidence, business passengers are not as price sensitive as leisure passengers. They will pay more to travel than leisure passengers. In a capacity constrained airport where there is business passenger demand, business passengers will displace leisure passengers since they will outbid the more price-sensitive leisure passenger for the available seats. In cross-examination, Mr. Brass was unable to identify where in his assessment he'd taken this into account. He simply had no answer to it. He presented an impact assessment which adopted the same business passenger elasticities in the with and without development scenarios up to the point where the airport becomes constrained. He then continued the growth using the same elasticity beyond 2030 in the with development scenario. In other words, his demand modelling did not address the fact that in a capacity-constrained airport where there is business passenger demand, business passengers will still fly because they will outbid leisure travellers on price. So BAL did not present any evidence which establishes that business passenger demand would be constrained in the do-nothing scenario, nor that there would be a net increase in business travel if planning permission were granted for the proposed development. So to conclude, it's submitted that in the absence of any evidence that demonstrates that there would be a net increase in business travel if planning permission were granted compared to the position if planning permission were refused, Mr. Ciro's balanced assumption has to be adopted with the consequent reductions in the economic impacts that this means. Turning then to displacement, a further and key aspect of considering the net economic benefits of the expansion of Bristol Airport is the concept of displacement, i.e. of ensuring that you consider the difference between the with and without development scenarios at different geographical levels. At the application stage, bizarrely, BAL contended that it wasn't relevant to consider displacement at all, and that was supported by an analysis of why other airports would not be able to meet the demand if planning permission were refused. BAL's case, as presented to officers in the committee, was accordingly that no other airport could meet the demand arising if permission were refused. This argument has been significantly modified since. At the end of November 2020, BAL published its ESA, which explained, as described above, the original assessment did not seek to quantify the potential offsetting effect on GVA and the employment impacts from passengers that cannot travel via Bristol Airport, transferring to other airports in the South West and South Wales to undertake their journeys if the proposed development did not go ahead. It was assessed that this effect would be likely to be limited. In contrast to the position adopted at the application stage, the data now presented by BAL suggests that if planning permission were not granted, rather than that demand not being met at all, it would be met in large part at other airports. Mr. Ciro explained in his evidence that of the two MPPA, planning permission were not granted, the new passenger allocation model identified that 1.24 million passengers would fly from other airports, with a total of 760,000 passengers who would not fly at all. According to the model, 570,000 passengers would fly from airports outside the region, of which 180,000 were identified as flying out of Heathrow. Mr. Ciro explained that this distribution in the no development scenario did not make sense. It has to be remembered that, after all, BAL started the year 2020 asserting to the Council that Heathrow and Gatwick would not meet any demand if planning permission were refused. Mr. Ciro explained, at present around 28% of passengers residing in the southwest of England fly from Heathrow. This is principally due to Heathrow providing flights to destinations not served by southwest airports, for example, North America, Middle East and Asia. In addition, flights out of Heathrow to European destinations tend to be more expensive than those from regional airports. It would therefore appear unrealistic to suggest that 24% of passengers in the west of England who were unable to fly from Bristol Airport for a week's holiday in Alicante, if it was unable to expand, would end up flying out of Heathrow to, say, New York. More likely, they would fly from another airport in the region to their preferred holiday destination, as airlines expanded services to meet that displaced demand. Hence, my view is that the displacement figures used by BAL represent a significant overestimate of the number of passengers who would fly from outside the region. He identified that as a result, the economic benefit of the proposed development has been significantly overstated. And so, from the outset, Jacobs, on behalf of the Council, sought information regarding that information in the passenger allocation model provided at the end of November 2020. It asked for information on the 23rd of December 2020, 21st of January 21, 13th of February, 15th of February, 4th of March, 9th of March, 16th of March, and on the 7th of April, Mr. Brass of York Aviation responded, "I've discussed with the airport. They are keen to try and understand a bit more about what you were trying to get from the data." On the 29th of April, there was a meeting regarding the Statement of Common Ground, at which there was insufficient time to go into the matter, but the draft Statement of Common Ground from June 2021 records that for the long-term forecast, an econometric passenger allocation model has been used. This examines how passengers make choices between the different airports available based on multiple variables. The appellants indicated that the values assigned to each variable differ by market segment. However, the values assigned to each market segment have not been provided, despite a number of requests that they should be. No reason has been given for the failure to provide this information, and the prospect of resolution of that issue was recorded as unlikely. In the absence of further information, Mr. Foley explained in his proof of evidence that he reserved his position on whether the passenger allocation model is appropriate. And as we've already explained, Mr. Ciro questioned the reliability of its output. Mr. Brass sought to contend that he had provided the information sought, and in cross-examination, that didn't end well for him. Shortly after the end of cross-examination, further data was provided. Jacobs requested a meeting to discuss that data, which had been provided as a single list of values absent any context. As a result, it became apparent that in order to understand the manner in which the passenger allocation model utilises the data provided, Jacobs needed to understand how the lambda value used in that model had been derived and verified. As already mentioned, the passenger allocation model is used to determine the probability of an individual using one airport over another, or not flying at all, based on a range of factors including generalised cost plus time taken to access each airport, airfare, frequency and destination served. The lambda value used in passenger allocation models dictates how sensitive passenger demand is to these range of factors, which then determines which airport, if any, a passenger will choose. The less sensitive, the higher the cost needs to be before a person changes their preference, and vice versa. Hence, it is important to know its value and derivation. Bowell and York Aviation's provided no information and evidence regarding the lambda value or how it was determined. This is important since even small changes in the value can result in major changes in the output of the model. It's also important to understand how benchmarking has been undertaken, since using a benchmark value from another airport may not be appropriate in the case of Bristol. In the absence of understanding the lambda value used in its justification, Jacobs has been unable to advise the Council that the passenger allocation model utilised by York Aviation is robust. Indeed, in the absence of any such understanding, the passenger allocation model has not been the subject of scrutiny by this inquiry, the Council, or indeed any third party. Notwithstanding an offer to treat the information provided confidentially, Bowell and York Aviation refused to provide any information. In effect, the refusal to allow access means that no view can be reached on the robustness of the passenger allocation model in circumstances where there is good evidence that its output is inconsistent with reality. The practical effect is that the model has not been subject to any meaningful form of public scrutiny whatsoever. Mr. David Lees, Bowell's chief executive, in the foreword to its 2019 airport monitoring report, refers to the ongoing commitment to engagement and transparency within our community. The refusal to allow access, even on a confidential basis, to the information necessary to enable the Council's consultants to determine whether the passenger allocation model is robust is the very antithesis of a commitment to engagement and transparency. It is an attempt to avoid scrutiny in a process where disclosure is required in the public interest. The extent to which the passenger allocation model is robust is a matter which is material to the determination of this appeal. As decision makers, you need to determine the weight to be ascribed to the model's output. Accordingly, in order to assist you, the Council needed to be provided with access to the model, even if this was only on a confidential basis. The Council submits that the passenger allocation model has not been the subject of public scrutiny. Through this process, the model has not been independently verified as robust, and there is no independent evidence that demonstrates that it is robust. Indeed, its output is unreliable for the reasons identified by Mr. Ciro. The model has not been the subject of any independent scrutiny whatsoever. As such, the output of that model and all of the impact assessments based on it, including, for example, the economic impact, the parking demand, the junction capacity assessments, can be given little, if any, weight. Indeed, if you as decision makers were to give any material weight to the output of the passenger allocation model, that would give rise to an error of law, namely a breach of natural justice, unfairness and substantial prejudice to the Council, which has been denied the opportunity to provide any meaningful response to the model regarding the lambda value adopted. The consequences of displacement. The Council's administrative area and the West of England generally are prosperous areas with average GDP per capita 20% higher than the UK, excluding London, average, as well as higher rates of economic activity and lower levels of unemployment than the national average. Employment growth between 2012 and 2019 was over 15% in both areas, and again higher than the national average, whilst levels of deprivation are significantly lower than the national average. Bristol Airport competes for passengers with other airports, and that is because their catchments and the destinations that they offer all overlap with Bristol Airport's. York Aviation previously advised that Bristol and Cardiff Airport's catchment areas overlap significantly, and the OFTs identified competition between Bristol and Exeter airports. Mr. Ciro produced his own estimate of the amount of displacement. His Table 6.4 examines the displacement effects without taking into account those who do not fly, and that reveals that the South West and South Wales level at the South West and South Wales level, the effect of granting planning permission is to reduce GVAN jobs at other airports that would otherwise occur at Cardiff, Newquay, Exeter and Bournemouth, with Cardiff being the hardest hit, losing between 40 and 58 million pounds of GVA, between 635 and 802 jobs, or between 525 and 647 FTEs. All of these airports lie in areas of greater deprivation than Bristol Airport, as Mr. Ciro demonstrated in his evidence, where he examined the GVA per head in the regions where the airports are located. This table shows that Cardiff and the Vale of Glamorgan together are substantially less prosperous than the area around Bristol Airport. The grant of planning permission would also have significant long-term implications for Cardiff Airport going forward. A grant of planning permission for expansion at Bristol will create a critical mass in favour of Bristol. As Mr. Ciro explained in his evidence in chief, this is likely to inhibit further growth as airlines will wish to come to the larger, expanded Bristol Airport and not the smaller Cardiff. Thus, it has future implications for the economy of South Wales beyond the losses identified by Mr. Ciro. For the purposes of the Levelling Up Fund, 3 of the local authorities in the West of England are level 2, whilst South Gloucestershire is level 3, i.e. least in need of levelling up. By contrast, the Vale of Glamorgan, where Cardiff Airport is located, is level 2, with all 3 of the local authorities which neighbour the Vale of Glamorgan, Cardiff, Bridgend and the Rhondda, at level 1. There is no doubt that the area around Cardiff Airport is considerably more deprived than that around Bristol Airport. Whilst there is no aviation policy which prioritises one area for growth over another, with the exception, of course, of the additional runway for Heathrow in the NPS, it is the case that the government is pursuing a levelling up agenda. In Build Back Better, the government explains that there are parts of the country where people feel left behind, that they're not getting fair access to jobs, wages and skill opportunities, and that their local priorities are not being delivered on by government. Levelling up is about improving everyday life for people in those places. It's about ensuring people can be proud of their local community rather than feeling as though they need to leave it in order to reach their potential. We will tackle geographical disparities in key services and outcomes across the UK, improving health, education, skills, increasing jobs and growth, building stronger and safer communities, and improving infrastructure and connectivity. We will focus on boosting regional productivity where it's lagging to improve job opportunities and wages. Above all, this is a plan that will build on the strengths of the Union. The Union is core to our economic model and at the heart of our prosperity. A decision to grant planning permission for the PROS development would be entirely contrary to these policy objectives. Mr. Ciro has demonstrated that expansion at Bristol Airport would come at real economic cost to the far more deprived economy of South Wales. It will result in hundreds of jobs that would otherwise be created in South Wales, not materialising there at all. And it's self-evident that to grant planning permission for the expansion of Bristol Airport would be contrary to the levelling up approach and to Build Back Better. It would simply reinforce to those in Cardiff, the Rhondda and Bridgend that they are to be left behind, that they are not to be prioritised in terms of access to jobs, wages and skills opportunities. They would feel as though they have to leave Wales in order to reach their potential. And it would simply reinforce the existing economic disparity between the West of England, and that in turn would undermine rather than support the union with Wales. In this context, it is small wonder that the Welsh Government has objected to the grant of planning permission on behalf of the entire Welsh nation. A grant of planning permission for expansion at the airport would achieve the very opposite of current government policy as set out in Build Back Better. It is contrary to that policy document and to the levelling up agenda, and this is a material consideration which must weigh heavily against the grant of planning permission. In terms of clawback of trips, Bristol Airport Limited contends that a grant of permission would result in the clawback of unsustainable trips of airports further afield, particularly Heathrow, but that conclusion is dependent upon the output of the passenger allocation model and something to be given limited weight for reasons already explained. In terms of outbound tourism, the airport principally serves an outbound tourist market which accounts for nearly 2/3 of its business. Mr. Brass takes no account of the economic effects of outbound tourism in his economic appraisal. The matter is simply excluded, and there's no policy basis for that exclusion. Moreover, while accounting for this effect is a complex matter, it is contrary to general principles of economic impact assessment to exclude it entirely. This needs to be included in assessment, not as part of any argument that suggests that people should be constrained from flying, but rather of ensuring that all relative costs and benefits are taken into account. Mr. Ciro assessed that the additional outbound trips that will occur as a result of the proposed development and the level of spend that is incurred outside the UK associated with trips abroad that it would generate. He then offset this against the spend that occurs in the UK in relation to overseas trips. The result is an annual negative impact of £123 million due to the increase in outbound tourism. This has to be taken into account when considering the overall economic impacts of granting planning permission. But all of that is not to overlook the social benefits of flying. However, since it's necessary to focus on the net impacts, in other words, those that occur by comparing the with and without development scenarios, it's crucial to recognise that the refusal of planning permission does not prevent people from flying abroad. Of the 2 MPPA, on Bow's case, 1.25 still fly if permission is refused. So there's no social impact upon them of refusal. Of the remaining 760,000 passengers, 650,000 are domestic who don't fly, but that doesn't mean that they don't have another holiday within the UK, or indeed that they do not travel abroad by other means. It can't be accepted that a holiday abroad is of greater social value than a holiday within the UK. As a result, there is no material social benefit in granting planning permission compared to refusing it, and that is a factor which is to be given limited, if any, weight. The connectivity of the UK, the government's objective is to make the UK one of the best connected countries in the world, and the policy is to be judged on a UK-wide basis. This means that what has to be judged in the present case is whether the grant of planning permission will result in net benefits to the UK as a whole in terms of connectivity that will not arise if planning permission is refused. But Bow's case in this regard is simply assertive. It says that there will be an increase in connectivity, but it provides no evidence. There's no appraisal before this inquiry which examines the net impact that the proposed development will have on connectivity at a national or even a regional level. It's not been established that the grant of planning permission for the proposed development would increase the number of routes or the frequency of service on routes to any particular destinations compared to the position if planning permission were refused. Indeed, Mr. Brass explained, we cannot sensibly know which airlines will be flying what routes and with how many passengers in 9 years' time. It has to be remembered that of the 2 MPPA growth, 1.24 will fly anywhere and the remainder is induced demand. There is then no evidence on which it can be rationally concluded that the grant of planning permission would deliver any material increase in the connectivity on either a UK-wide basis or indeed any other geographical basis compared to the position if planning permission is refused. As a result, in the total absence of any net benefit, this is a factor to which no weight can be ascribed. Bow has completely overstated the importance of the benefits the proposed development will deliver. For example, its economic benefits are small when compared to, say, those of the Junction 21 enterprise area. The airport is far from the most important element of growth in the local economy. After all, as we've explained, the development's NPV benefits represent about £10 million a year. That's not even enough to return the airport to profitability, assuming that its 2019 loss of £33 million continues for the foreseeable future. Now that carbon costs have been properly accounted for, the benefits of the proposed development are, in the context of the area, economically small. Turning to regeneration of deprived areas, in its statement of case, Bow identified that the proposed development would support regeneration, including in two of the southwest most deprived areas, Weston-super-Mare and South Bristol. It now transpires that the regeneration is not any physical regeneration as such within these areas, rather it's a skills and employment plan secured by planning obligation. Whilst welcome and supported by financial contribution, the scale of which is yet to determine, but which will be up to 300,000, it would be easy to overstate the significance of this plan. It is a drop in the ocean compared to the investment in physical generation which South Bristol and Weston-super-Mare require. Further, one of the major barriers to work at the airport from both South Bristol and Weston-super-Mare is access via public transport on a 24/7 basis. The mitigation on offer does not include guaranteed public transport access by staff who will be working on a shift basis 24/7. There is no evidence of how the public transport improvements will help these members of staff in any practical way, such that travel by public transport is realistic and reliable, particularly when working shifts. For the low-paid who cannot afford the costs of running a private car, the absence of such public transport access is highly likely to prevent them from taking up any employment opportunities that arise. Accordingly, BAL again overstates the extent of the benefit that will be provided in terms of reducing deprivation in South Bristol and Weston-super-Mare. There will be some, but in terms of the context of those areas as a whole, it will be economically small and thus of little weight. Conclusions on benefit. The economic benefits of Bristol Airport's expansion are significantly overstated and will not provide significant economic benefits as claimed. All the other claimed benefits have been addressed already. Turning to the Stansted decision, the statutory review of Stansted decision is not yet finally determined. In any event, there's a great danger in lifting conclusions from that decision letter into the determination of the present appeal. Each appeal falls to be determined on its merits by reference to the evidence and submissions presented. As far as we are aware, no party to the Stansted inquiry contended that MBU was out of date, nor that the grant of planning permission would be contrary to the duties in the CCA 2008, nor that a grant of planning permission would be premature. All of these matters have been argued in the present case in detail. It is, with respect, your duty to determine this appeal by reference to the evidence and the submissions that have been made. That duty will not be fulfilled simply by following blindly the conclusions of other inspectors which are founded on other evidence and other submissions. Turning to the planning balance, Section 38(6) of the 2004 Act requires a decision maker to determine whether the proposed development accords with the development plan. We've provided references to case law in our detailed closing submissions, which we submit mean that in determining the appeal, you must begin with the development plan policies and decide overall whether the proposed development accords or conflicts with the plan as a whole. Then, in conducting that exercise, you must construe the policies correctly, and the application of the facts to the policies within the development plan is a matter for you. The weight you give to the development plan and to all material considerations is also a matter for you. We submit that the proposed development is contrary to the development plan in numerous respects, as we've explained, and was set out in the reasons for refusal. It's agreed that the development plan has full weight. Accordingly, the development plan provides very significant weight against the grant of planning permission. Applying Section 38(6), planning permission for the proposed development must therefore be refused unless material considerations indicate otherwise. The APF and MPU are both material considerations in the determination of this appeal, just as the MPPF is. And just like the MPPF, they both require an exercise to be undertaken in order to determine whether they weigh in favour or against the proposed development. That exercise requires the decision maker to weigh the costs and benefits of the proposed development against one another and determine generally whether the proposed development accords with each document. We have already explained that the proposed development conflicts with the APF in a number of respects, including the failure to provide those living around the airport with any share, let alone a fair share, of the benefits of expansion, and the failure to expand without making noise worse in the past, and the failure to provide a fair share of benefits of noise reduction produced by technological improvement. It's also the case that the adverse impacts associated with the residual net effects of climate change, noise, air quality, surface access, health and the greenbelt significantly outweigh the economically small net benefits that the proposed development would deliver. There is no freestanding support for the expansion of airports to be weighed in this balance, and to include this as a freestanding material consideration weighing in favour of the development would be an error of law. On this basis, it's submitted that it is demonstrably the case that the costs of expansion outweigh the benefits. It follows that the condition of support provided by APF or MBU is not fulfilled, and the proposed development is contrary to national aviation policy. It is planning law that the weight to be given to all material considerations is a matter for you. Mr. Melling's approach to national aviation policy was that he gave these documents full weight and contended that the questions as to whether they were up to date or not were irrelevant. That approach is totally flawed, and to follow it would result in error of law. As we've explained, any policy supporters there may be in the APF or MBU is out of date. So even if you conclude that the proposed development obtains the conditional support of these policy statements, that support can only be given limited weight in the Section 38.6 balance. By contrast, it has not been demonstrated that where conflict with national aviation policy arises, that that the support that these policies give to refusal is out of date. Accordingly, once you accept the submission that there is a conflict with the APF or MBU, it follows that these documents provide very significant weight against the grant of planning permission. So far as the Greenbelt balance required by the NPPF is concerned, the harm by reason of inappropriateness and to the openness and purposes of the Green Belt, which is given substantial weight, coupled with the very significant other harm we have already identified, significantly outweighs the flawed attempt to suggest that parking is required in the Green Belt. The conflict with Green Belt policy at the national and local level weighs very significantly against the grant of planning permission. The proposed development also conflicts with numerous policies within the NPPF in terms of climate change, noise, air quality, surface access and health. Paragraph 11D doesn't bite, and it's agreed that it's paragraph 11C which is to be applied, and that provides, I've set it out, I'm not going to read it out because you're familiar with that. It's submitted that that requires application of the general Section 38.6 approach. North Somerset Council submits that the material considerations that weigh in favour of grant do not come close to rebutting the presumption in favour of refusal due to the conflict with the development plan and the material considerations which together weigh significantly against the grant of planning permission. The only reasonable outcome of the Section 38.6 approach is to conclude that planning permission must be refused. The proposed development is not sustainable development. Indeed, so much so it would be unlawful to grant planning permission for it, as to do so will breach Sections 1 and 4 of the Climate Change Act 2008. BAL has not pursued a development which comes close to delivering the fair balance national aviation policy requires between its interests and those whose health and quality of life its activities affect. Rather, it has pursued growth to meet its own interests, failed to design in mitigation from the outset. Even now, its proposals for noise mitigation continue to evolve. Further, it has sought to avoid public scrutiny of key aspects of its arguments. It has, in short, sought to obtain planning permission to expand on a basis that is the very opposite of the responsible growth required by government. It is time to send a message to airport operators like BAL who consider themselves to have a license to grow. They do not. The small economic benefit which the proposed development would deliver, just 10 million a year, doesn't come close to justify the sleepless nights for thousands living around the airport or the harm to health and quality of life that would be visited on them. This is the wrong development, proposed in the wrong location, proposed at the wrong time. It would be unlawful to grant planning permission for the proposed development, and it is in any event a scheme which is entirely unacceptable. On behalf of North Somerset District Council, we ask you to refuse planning permission.
Excuse me. Thank you very much, Mr. Taylor and Mr. Henderson. And we will obviously look at the full version, as it were.
I'm sorry to inflict such a detailed appraisal on you, but we hope it's of assistance.
Absolutely. Right, thanks very much. Unless there's any last-minute housekeeping matters, I think we're there for today. I assume we're going to revert to 9:30 start tomorrow, in that I haven't heard any requests not to, so that's okay, is it? Good, thank you very much. Okay, then we're adjourned till 9:30 tomorrow. Thank you.